Honorable President, Honorable Judges, I'm Silver Lumumbaya, Advocate and Consul from the Democratic Republic of Congo. Thank you. Honorable President, Honorable Judges, I am Barrister Jedene Wedugaya, Consul for the Democratic Republic of Congo. President, Honorable Judges, Trésor Mwandi Kunya, Consul for the Democratic Republic of Congo. Honorable Judges, I'm Barrister Mwende Kandandungu for the Democratic Republic of Congo. Honorable President, Honorable Judges, Professor Ezekiel Labani, Consul for the Democratic Republic of Congo. Honorable President, Honorable Judges, Professor Balingene Taumbo, Consul for the Democratic Republic of Congo. Honorable President, Honorable Judges, Barrister Prosper Balulali, Consul for the Democratic Republic of Congo. Honorable President, Honorable Judges, Professor Fils Angelesi, Consul for the Democratic Republic of Congo. Honorable President, Honorable Judges, I'm Blaise Ndombe, Consul for the Democratic Republic of Congo. Thank you. The respondent state, Rwanda, will now introduce members of its team. Honorable Judges, I'm Barrister Rukangu Mike, Consul for the Republic of Rwanda. To the parties for presentation of the consuls. Now, so I'll give the floor to the respondent state to make its presentation on jurisdiction which it would like to present before the court. You have 2 hours. We would like you to keep to time exactly 2 hours. You have the floor.
Been an opportunity for the African international justice system to actually thrive. Instead, the applicant put to you and to all of us in the delicate and untenable situation of having to address a case procedurally flawed in so many respects that it does not have a leg to stand on. The only proper cause is to dismiss it. This is why, before turning to the respondent's contentions on jurisdiction and admissibility, I would like to address the significant procedural lapses in the applicant's case and the flawed approach with regard to the manner in which and grounds upon which this case has been brought. From its inception, this application has been marked by lack of coherence, procedural irregularities, and an outright disregard for the established principles governing the court's jurisdiction and admissibility requirements. It is not merely flawed, but fundamentally untenable. Let me first deal with the issue of the applicant's procedural lapses. Starting with the procedural record, we wish to underline significant shortcomings in the applicant's approach, which should raise concerns about its compliance with established procedural norms. This includes the filing of an additional application for an expedited procedure, which is an unprecedented move that had no justification. one might be forgiven to speculate that the applicant's government had simply wanted a quick win to trumpet before an upcoming election. Well, the court has rightly set aside this request. It exhibited from the outset the applicant's unwillingness to respect proper forms and procedure. This was confirmed by another rather undiplomatic incident when a member of the DRC's government visited the court in August 2024 with very little notice, perhaps in an attempt to intimidate its members. This is unheard of. President of the court, members of the court. Graver yet was when the applicant sought to lodge 11th hour observations to the respondent's rejoinder in another breach of procedural norms that underscores the opportunistic and unstructured nature of the applicant's approach to this case. Well, we consider these observations procedurally inadmissible. They are also unworthy of the court's attention when they did not merely restate the applicant's flawed arguments. They sought to obfuscate the proceedings further with meritless arguments and misreadings of the respondent's case. And of course, an even more flagrant example of the applicant's cavalier attitude to these proceedings can be found in its filing duplicative claims before the East African Court of Justice. The applicant failed to disclose these parallel proceedings, disingenuously asserting that there was no ESCJ case when it lodged its application before this honorable court. Yet, within a month, the East African Court of Justice filing was submitted, proving the applicant's knowledge at the relevant time. As we established in the rejoinder, the applicant even attempted to recycle these proceedings documents before the East African Court of Justice, providing irrefutable evidence not only of its attempt to secure duplicative relief, but also that these cases are inextricably linked. It should therefore be clear that the applicant's attempt to conceal its litigation strategy erodes the principles of good governance and transparency essential to international adjudication. We could go on. The procedural record is replete with such guerrilla tactics from the applicant. Suffice it to say that such conduct is not only procedurally improper, but also profoundly corrosive to the integrity of international adjudication. It is incumbent upon this honorable court to firmly reject such tactics, which, if left unchecked, will diminish its standing and invite further attempts to manipulate these proceedings. Let me also briefly deal with the applicant's flawed approach to this case's lack of legal basis. Beyond its disregard of the applicable procedural rights, the applicant's approach to the case legal issues can only be described as scattershot and impressionistic. The applicant seems to be under the impression that it suffices to invoke a bewildering array of legal instruments and alleged norms without demonstrating their applicability, let alone their ratification or even binding nature upon the respondent. Needless to say, this is not how international justice works. Well, we will later elaborate on why the court lacks jurisdiction to address the merits of the applicant's case. I would like to shortly focus on general approach adopted by the Democratic Republic of Congo in this case. In brief, the applicant's excessive and unfocused strategy appears designed to overwhelm the court with sheer volume rather than to engage meaningfully in its jurisdiction and substantive standards. Indeed, the applicant has failed to establish even the most basic elements of the court's jurisdiction, including the existence of a bona fide legal dispute at the time of filing. President of the court, honorable judges, this lack of focus was even more illustrated in the applicant's failure to entertain or even acknowledge some of the preliminary objections raised by the respondents. Parties in international proceedings have duties. In particular, they should do their utmost to place the court or the tribunal in the best position to rule fully upon the case. This ensures efficiency and the fair settlement of disputes, as well as the legitimacy and the strength of the resulting decision. By contrast, the applicant has opted to raise as many arguments as possible while ignoring the respondent's legitimate objections, and is now simply hoping that the court will somehow sort out its case. Its last-minute attempt to remedy this lapse in its inadmissible observations only compounded the limitations of this approach. Chief amongst the issues that the applicant has failed to deal with, the required seriousness, is the exhaustion of local remedies. This cornerstone requirement of international human rights law, deeply enshrined in this court's own jurisprudence, has been entirely bypassed, even though there is absolutely no dispute that the burden of proof is on the applicant to prove that such remedies have been exhausted or are not required. The respondent has dealt at length and in details with the judicial mechanisms that were and still are available to the applicant and the individual it purports to represent. These mechanisms are fully operational, accessible, and effective, a fact that the applicant has utterly failed to rebut, preferring to believe that it is not bound by the usual rules of admissibility. This alone would render this application inadmissible. The applicant's treatment of this critical issue has not been an exception. Its general attitude has been to offer no coherent rebuttal of the key jurisdictional and admissibility issues, but instead to rely on vague, impressionistic assertions unsupported by evidence or legal authority, as if the mere invocation of human rights could substitute for rigorous legal argumentation. President of this tribunal, members of the tribunal, this case is therefore remarkable, be it for its procedural chaos or for its substantive deficiencies. We do reckon that this case is remarkable, but it's couched with a lot of procedural chaos and substantive deficiencies. As I now leave the floor first to Professor Dapo Akande today to set out arguments on lack of jurisdiction, and then tomorrow to Dr. Owiso, who will deal with the inadmissible nature of the claims made in these proceedings, it is essential to underscore that the procedural and substantive deficiencies of this case form a critical background to our submissions. The lack of coherence, procedural lapses, and disregard for established principles must guide this court's understanding of why the application is both inadmissible and outside its jurisdiction. Thank you, Mr. Presiding Judge and Vice President of the Court, and the members of the Honorable Court for your kind attention. And I would invite you, Mr. President, to call upon Professor Akande to proceed with the issue on jurisdiction. Thank you very much.
Mr. Vice President, members of the court, it's an honor to appear before you today and to do so on behalf of the Republic of Rwanda. My task this morning is to set out the argument that the matters that are covered in the application filed by the Democratic Republic of Congo are not within the jurisdiction of this honorable court. I begin by stressing, as our agent has already indicated, that Rwanda has deep respect for the high functions which this court is called upon to fulfill. Rwanda agrees that the court has an important role to play in the protection of human rights in Africa. However, that important role is entrusted to the court strictly within the terms of the African Charter on Human and People's Rights, and particularly within the terms of the protocol on the establishment of this court. The court, as a judicial body, one of the highest judicial bodies on the African continent, performs its functions in accordance with the specific mandate that has been conferred upon it. That specific mandate sets out and defines the jurisdiction of the court, and as will be explained by my colleague Dr. Owiso tomorrow, also sets out the circumstances in which applications are admissible. The court itself recognizes the importance of only determining the merits of applications that are filed by parties in circumstances where those applications fall within the jurisdiction of the court and are admissible. This is why Rule 49, Paragraph 1 of the Rules of Court, adopted by this court, provides, and I quote, "The court shall conduct preliminary examination of its jurisdiction and admissibility of an application in accordance with the Charter, the protocol, and these rules." The court faithfully applies this provision in practically every case that is brought before you. And as is evident from your judgments, you conduct that preliminary examination carefully. So in raising the preliminary objections now before the court, Rwanda has done no more than to assist the court in the task which the court is called upon to engage with. As this matter is the first interstate case that has been filed before this court, it is even more important that questions relating to jurisdiction and admissibility are examined with rigor. What is at stake here is the question of the scope of the consent that states like Rwanda, which have become parties to the protocol, have given to the court's jurisdiction. The question is this: in relation to what exactly have these states agreed to adjudication by this honorable court? The applicant has argued that Rwanda is taking a formalistic approach to these matters of jurisdiction. But that is because they wish to play fast and loose with the terms of the protocol. What we argue for is that the court should do what it always does, which is to stick strictly to the competence that has been conferred upon it. Mr. Vice President, honorable members of the court, Rwanda submits that the application filed by the applicant falls outside of the jurisdiction of the court in two broad respects. First, the claims of the other side fall outside of the material jurisdiction of the court. Or to put it in other terms, the claims are outside the subject matter jurisdiction of the court. Second, the claims also fall outside the territorial jurisdiction that is conferred on the court, since the violations that are alleged by the DRC were not committed on the territory of the respondent state. Mr. Vice President, members of the court, let me begin our submissions by first addressing you on the issue of territorial jurisdiction. In our written pleadings, Rwanda first addressed the material scope of your jurisdiction. We fully maintain all our arguments that show that this case falls outside the material jurisdiction of the Honorable Court, and I will address those issues in a moment. However, in these oral hearings, we begin with the submission that the matters brought before the court fall outside the territorial jurisdiction of the court. We start here because the points are very straightforward. Your jurisprudence on this point is abundantly clear. The insistence that the alleged violations must have taken place on the territory of the respondent state has been so consistent that one can hardly misunderstand it. However, somehow, the applicant claims that this requirement does not exist. This is a most unusual case that has been brought before this court. It is not only unusual, it is unique. The aim is to greatly expand the jurisdiction of the court to matters that are beyond what you have consistently found to be within the limits of your jurisdiction. The case is unique, not because it is the first interstate case brought before this court. It is unique and it is inappropriate because it aims to do something that you have consistently held is not to be done. The case aims to bring within the jurisdiction of the court matters which did not occur on the territory of the respondent state. There's an important reason why the territorial jurisdiction of this court is confined to facts that occurred within the territory of the respondent state. It is only in that space that the respondent has such control that it can actually fulfill its obligations under the relevant treaties. The attempt of the applicant to change the clear requirement of territorial jurisdiction set out by this court is an obvious attempt to involve this court in matters concerning the use of force and matters implicating challenging issues regarding the maintenance of peace and security, and it should be rejected. We request the court to find that this case, which relates to matters that did not occur within the territory of Rwanda, falls outside the territorial jurisdiction conferred on the court. In each case that is brought before this court, you carefully consider whether all aspects of your jurisdiction have been satisfied, and you have always indicated that one such aspect of jurisdiction that must be satisfied is territorial jurisdiction. You have also defined that territorial jurisdiction very clearly and in the same way. In so many cases, more cases than we can cite, but we cite many in our preliminary objections and also in our rejoinder, you have said that there is, and I quote your jurisprudence, there is territorial jurisdiction insofar as the violations alleged by the applicants occurred on the territory of the respondent state. End quote. You've held that in many cases. In other cases, you have said essentially the same thing by holding that you have, and again I quote several cases from the court, you have, quote, territorial jurisdiction since the facts of the case occurred in the territory of a state party to the protocol, namely the respondent state, end quote. In both of these formulations, the key point is that the alleged violation of human rights arises on the territory of the respondent state. The applicant seeks to avoid this key point and this court's consistent jurisprudence by making a number of arguments, all of which are ultimately misguided. They say that the relevant criterion is not that the violation occurred on the territory of the respondent state, but in their view, what is key, and I quote their reply, what is key is the state party status under the relevant instruments conferring such jurisdiction on the court. But this argument is plainly wrong. In the first place, there are many cases where this court doesn't even mention doesn't even mention that the facts occur on the territory of a state party when dealing with territorial jurisdiction, but simply indicates that there is territorial jurisdiction because the facts occurred on the territory of the respondent state. Second, to say that the relevant criterion for territorial jurisdiction is the status of the respondent state as a state party to the protocol is to confuse territorial jurisdiction with personal jurisdiction. But the court is not confused. In each and every case, this court first examines whether it has personal jurisdiction. And with regard to that issue, it examines whether the respondent is a state party to the protocol. That is what gives the court personal jurisdiction over that state. Having examined that issue, the court then considers the separate issue of territorial jurisdiction. It cannot be that the court is then saying that territorial jurisdiction is again determined by the status of the state as a state party to the protocol. Instead, the court is clear that territorial jurisdiction is dependent on whether the facts have occurred on the territory of the respondent. This is why in each and every case, whatever the small deviations of the wording, the court checks to make sure that the facts have occurred in the territory of the respondent state. Not just any state, not just any state party to the protocol, the court always determines that it has territorial jurisdiction because the facts have occurred in the territory of the respondent state. The applicant's confusion of territorial jurisdiction and personal jurisdiction is even more evident in its argument that if the court were to accept that its jurisdiction only relates to matters occurring within the territory of the respondent state, in their view, they say this conception of jurisdiction ratione loci could only apply, and I quote from the applicant's reply, could only apply in respect of human rights violations committed in the territory of a state party, in the territory of a state which is not a party to the protocol or the charter. So they say it could only apply in respect of human rights violations committed in the territory of a state which is not a party to the protocol or the charter, end quote. This is very confusing because if the state is not a party to the protocol or the charter, the court would have no personal jurisdiction with respect to that state. So how could this concept only apply in relation to states not party to the protocol or the charter? The two requirements, that one, for personal jurisdiction to exist, the respondent must be a state party to the protocol, and two, for territorial jurisdiction to exist, the conduct must occur in the territory of the respondent state, are very clearly stated in the information that this court presents on its website about its jurisdiction. There, it is clearly stated, and I quote, "The court can only deal with cases submitted against countries that have ratified the protocol and deposited the Article 34(6) declaration in cases involving individuals and non-governmental organizations. The case must involve allegations of human rights, and those alleged violations must have taken place in the state concerned after it ratified the protocol. Those alleged violations must have taken place in the state concerned after it ratified the protocol, unless alleged violations are ongoing." End quote. Moreover, when the court presents information about the procedure and the conditions relating to filing a case, the court specifies very clearly, and again I quote, "Territorial jurisdiction requires the alleged violations to have taken place in the state concerned." End quote. None of this could be any clearer. The applicant argues that if the position of Rwanda, our position, that the alleged violations must occur in the territory of the respondent state, if that position were to be accepted, they say this would render the African human rights protection system devoid of all substance and usefulness. But how could this possibly be the case? After all, in every other case before this court, the facts have occurred in the territory of the respondent state. This has not made the African human rights protection system useless, as they suggest. Indeed, the system is working. It is the applicant that is trying to upend things by bringing the sort of claim that has never been brought before this court. It is their conception of territorial jurisdiction that would radically change the African human rights system. This is particularly so as the claims of extraterritorial violation are, as in cases like this, they're likely to be brought in matters which implicate peace and security and therefore beyond the court's jurisdiction. We submit that the court should not depart from its established jurisprudence, and the court should hold that this case falls outside the territorial jurisdiction conferred on the court because the facts occurred outside the territory of Rwanda. Mr. Vice President, members of the court, permit me now to turn to our submissions that the matters brought before the court are outside the material jurisdiction of the court. The claims of the applicant fall outside the court's material jurisdiction in two separate and distinct ways. First, the matters that are included by the DRC within its application were not the subject of a relevant dispute between the parties at the time when the application was filed. So the matters were not the subject of a relevant dispute between the parties at the time the application was filed. Rwanda submits that the DRC brought its claims in a rather hasty and precipitous manner. We submit that the court only has jurisdiction in interstate proceedings where the matter submitted to the court was already in dispute at the time of the filing of the application. The applicant has failed to demonstrate that such a dispute on the claims brought to this court, they failed to demonstrate that such a dispute existed between the parties at the time the application was filed. So that's our first argument on material jurisdiction. The second reason why at least some of the matters submitted to the court fall outside the court's material jurisdiction is that these matters do not, as required by the protocol, they do not relate to a relevant human rights instrument ratified by Rwanda. So we submit that some of the matters submitted to the court do not relate to a relevant human rights instrument ratified by Rwanda. The scope of the court's jurisdiction is set out in Article 3, Paragraph 1 of the protocol. As with other international courts, the jurisdiction of the court is constrained by what states parties to the instrument establishing the court have consented to. It is this provision, Article 3, Paragraph 1, that sets out what the states parties to the protocol have consented to, and it is important for the court to stay within the limits of that consent. It may be useful to remind ourselves of what Article 3, Paragraph 1 actually says, not least because at times one gets the impression that the other side have paid little attention to the text of the provision. So with your indulgence, let me read it out. It provides, and I quote, "The jurisdiction of the court shall extend to all cases and disputes submitted to it concerning the interpretation and application of the Charter, this protocol, and any other relevant human rights instrument ratified by the states concerned." Mr. Vice President, honorable members of the court, let me now address these submissions in detail. Our first submission on lack of material jurisdiction is that the court lacks material jurisdiction to consider matters in the application filed by the DRC because in interstate cases such as this one, the jurisdiction of the court only extends to disputes which existed between those states at the time when the application was filed. I will first show that this requirement of the existence of a dispute is one that applies to the jurisdiction of this court in interstate cases. I will then show that at the time when the DRC filed its application, there was no dispute between the parties with respect to the matters that fall within the application. Now, the requirement of the existence of a dispute at the time of the filing of the application follows first and foremost from the text of Article 3.1, which I have just read out. That provision does not only say that the jurisdiction of the court extends to cases submitted to it, but it specifically mentions that the jurisdiction of the court extends to, and I quote, disputes submitted to the court. This means what it says. For a dispute to be submitted to the court, it must actually exist at the time when the application is brought. This requirement that there be a dispute between the parties relating to the subject matter of the case and existing at the time of the initiation of the case is consistent with the practice of other international courts and tribunals that deal with interstate proceedings. In fact, the language of Article 3 of the Protocol, when it speaks of submission of disputes to the court, is reminiscent of the language of the jurisdictional provisions of the statutes of other international courts that deal with interstate cases. In particular, Article 38(1) of the Statute of the International Court of Justice similarly speaks of the functions of that court, the ICJ. So Article 38(1) of the ICJ statute speaks of the functions of that court as being to decide, and I quote, such disputes as are submitted to it. Such disputes as are submitted to it. The similarity in the language to that in the protocol is obvious. The protocol of this court speaks of, I quote, disputes submitted to it. The statute of the ICJ speaks of such disputes as are submitted to it. That similarity is not accidental, and frankly, is not surprising. The drafters of the protocol of this court, of course, were well aware that in Article 5, the protocol contemplated that the court would preside over proceedings brought by states against other states parties to the protocol. They accordingly, and certainly, took care of adapting the protocol's language to the deference that is typically shown to sovereign states in international legal proceedings. Now, it is also not of great surprise that the requirement of a dispute has not so far been elaborated upon in the jurisprudence of this court. After all, this is the first interstate case that has been filed before this court. And so this court has so far, for that reason, not yet had opportunity to consider what jurisdictional issues arise in the specific and different context of interstate proceedings. If I may say, what is surprising is that the other side suggests that the court should deal with this case just as it had dealt with all the previous cases, though those cases were brought by individuals against states. There are features which are specific to interstate proceedings, reflected in the drafting of that provision, which, as we've just seen, borrows from the language of the ICJ statute. And it is important for those features to be considered in these particular proceedings. Now let us look at the practice of other international tribunals that have in their founding treaties comparable language specifying that the function or the jurisprudence of the court extends to disputes submitted. Let's look at the practice of other tribunals that deal with this language of dispute submitted to the court. The International Court of Justice has held that two things follow from this language of submission of disputes. First, and I quote, the court has said, the existence of a dispute between the parties is thus a condition of the court's jurisdiction. I quote again, the existence of a dispute between the parties is thus a condition for the court's jurisdiction. This is in the case between the Marshall Islands and the United Kingdom. And with your indulgence, Mr. President, all the citations are in our pleadings, and we will also submit them with the notes of these oral pleadings, the citations to these cases. So that's the first thing. The existence of a dispute is thus a condition of the court's jurisdiction. Or as the president of the ICJ stated in that same case, and I quote, the existence of a dispute between the parties to a case is not only a condition for the exercise of the court's jurisdiction, but more fundamentally, a condition for the very existence of that jurisdiction. End quote. The second thing that follows from this language of dispute submitted, is that the court will only have jurisdiction over a particular claim where there was a dispute between the states concerned at the time when the application was filed. The ICJ has put it in this way, and I quote, in principle, the date for determining the existence of a dispute is the date on which the application is submitted to the court. The ICJ has held this in several cases, exactly that same language, and you will find the citations in our pleadings. The court, the ICJ, stated that this condition follows from the language of its statute. Language that we have seen is very similar to the language used in Article 3 of the protocol of this court. The language in both instruments is of a dispute being submitted. That submission happens when the application is filed. However, the thing that is being submitted, the dispute, it must actually exist at the time. The alternative is a logical impossibility. States cannot submit a dispute that does not exist. Moreover, states cannot use the filing of a case as a way of manufacturing or creating a dispute. The dispute must exist, and then it is submitted. The applicant in this case argues, despite the clear language of Article 3, that there is no requirement of the existence of a dispute. It seems to be their wish that the court read Article 3 as if those words, which speaks of disputes submitted to the court, are not present. But the words are there, and the court must give them meaning. It's not entitled to ignore them. The applicants have come up with all manner of arguments to counter this requirement of the existence of a dispute at the time of the filing of the application. They argue that Rwanda's approach is one concerning what they call traditional litigation. And they say that we confuse that kind of litigation with the requirements of human rights litigation. They contend that the procedural requirements of human rights litigation, particularly before this court, are, I quote, generally flexible. That's what they say. They say that the drafters of the protocol, and I quote their reply, intended to create a court that is flexible and adaptable in the exercise of its jurisdiction. End quote. And in this regard, they seek to draw a contrast between how states express their consent to the jurisdiction of the ICJ and this court, as they also draw a contrast between the missions of both courts. In their view, the requirement of the existence of a dispute is pure formalism. Furthermore, the applicants place reliance on the provisions of the African Charter relating to and the practice of the African Commission of Human and People's Rights. They place reliance on the provisions of the African Charter relating to the practice of the African Commission of Human and People's Rights to suggest that even in interstate cases, there is no requirement of the existence of a dispute. Finally, they say that the term case, which you find in the protocol, and the term dispute, which we also find in Article 3.1, they say that these words are to be used interchangeably. They suggest no implications should be drawn from the use of one term or the other. Mr. Vice President, honorable members of the court, each and every one of these arguments is misconceived, and in some cases, they are incomprehensible. Let me address them one by one. First, the idea that the requirement of the existence of a dispute is not one which finds a place in human rights litigation flies in the face of the application of that same requirement to several interstate cases concerning human rights and brought under various human rights treaties. The ICJ considered and restated this requirement of the existence of a dispute in the case concerning the application of the International Convention on the Elimination of All Forms of Racial Discrimination between Georgia and the Russian Federation. And in that case, dealing with the Racial Discrimination Convention, the court engaged in a detailed inquiry of whether the two states had been involved in a dispute on that subject matter at the time the case was lodged before it. That's a racial discrimination case. In a case brought under the Convention Against Torture, the ICJ reiterated that jurisdiction hinges upon the existence of a dispute at the time the application was filed. This was a case between Belgium and Senegal regarding the obligation to prosecute or extradite. In fact, in that interstate case, undoubtedly, human rights interstate litigation, it also offers an example of the legal consequence attaching to a lack of a dispute at the time of the submission. The ICJ not only examined whether a dispute existed between the parties regarding the Torture Convention, it also went on to examine whether a dispute extended to breaches of customary international human rights law. The unanimous bench in that case found that there was, at the relevant time, a dispute relating to the Torture Convention, and for that reason found that it had jurisdiction with respect to that dispute. A large majority of judges also held that there was no dispute between those states relating to breaches of obligations under customary international human rights law, and held that the court had no jurisdiction to deal with Belgium's claims in that respect. As the applicant itself has recognized, the ICJ has also applied the requirement on the existence of a dispute in several cases brought under the Genocide Convention. It's done so in 3 recent cases, all of which are referred to in the applicant's own reply brief. The case between South Africa and Israel concerning the application of the Genocide Convention in the Gaza Strip, the case between Ukraine and Russia concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, the case between Gambia and Myanmar concerning the application of the Prevention and Punishment of the Crime of Genocide. All interstate human rights cases, the ICJ applied this requirement that a dispute must exist at the time of submission. Finally, on this point regarding the application to human rights cases, final point here. The DRC is well aware that this requirement of the existence of a dispute also applies in human rights litigation, not merely from all of these other cases, but also from the experience of the DRC itself in prior interstate litigation that it has been involved in relating to human rights. In a case between the same parties as are now before this court, the DRC and Rwanda, the ICJ applied this requirement to a claim that was brought by the DRC in relation to the Convention on the Elimination of Discrimination Against Women, Human Rights Treaty. This is the case concerning armed activities on the territory of the Congo, new application, in which the court found that it lacked jurisdiction, 2006. Mr. Vice President, honorable members of the court, we urge the court to dismiss the submission that this requirement of a dispute does not apply in a case such as this. This requirement follows from the terms of Article 3 of the Protocol, which in turn represents the scope of what the parties to the Protocol have consented to. They have only consented to the jurisdiction of the court in interstate cases insofar as a dispute that actually exists at the time, is submitted to it. The court is bound to respect that consent and thus to respect the jurisdictional limits set out in the Protocol. And moreover, there is no reason why the court should depart from the practice of other international courts and tribunals like the ICJ, whose jurisdictional instruments similarly refer to the submission of disputes. The second reason to reject the applicant's arguments as to the existence of a dispute is that it is simply wrong to say that this requirement leads to formalism. As the applicant itself has noted, the ICJ has stated on many occasions, and I quote, "The court's determination of the existence of a dispute is a matter of substance, not form or procedure." There is no formalistic approach to the determination of whether there is a dispute. What is required is an examination of the real state of affairs between the states concerned. A third reason for rejecting the argument that there is no requirement of a dispute is that the applicant confuses the requirements for submitting a communication to the African Commission on Human Rights, Human and People's Rights, with the jurisdictional constraints on this court. They insist that a state is able to submit a communication directly to the Commission against another state without first bringing the matter to the attention of the state that is complained against. They then say it must also be possible before this court. The DRC bases this suggestion on what it describes, and I quote from their reply, it describes as a combined reading of Articles 47, 48, and 49 of the Charter. However, reliance here on the provisions of the Charter dealing with submissions of communications to the Commission is misguided. This court is well aware of the fact that the provisions of the protocol relating to the procedure by which cases are submitted to the court are not the same as the provisions of the Charter relating to the submissions of communications to the Commission. As you have previously stated, and I quote, in the case between the African Commission on Human and People's Rights and Kenya, as you stated, and I quote, the court is of the view that admissibility and other procedures relating to a complaint before the Commission are not necessarily relevant in determining admissibility of an application before this court. Now, this was said in relation to admissibility, but the court also spoke about other procedures relating to a complaint. And the same thinking applies also to the rules regarding jurisdiction. Simply put, those rules are not exactly the same for the Commission as for the court. Otherwise, the protocol and its carefully delineated language would serve no purpose. In any event, the provisions in Articles 47 to 50 that they rely on, though not directed at the court, they show how the drafters of the Charter did have in mind that before African institutions are engaged by states who are of the view that violations have occurred, that there should be an attempt at friendly settlement of the issue with the allegedly wrongdoing state. Now, although a state may submit a communication to the African Commission without first having communicated the matter to the state, the Commission is then tasked with seeking a friendly settlement, or what the Charter refers to as an amicable solution. So to compare this careful, amicable process with the unilateral filing of a legal dispute before this court is disingenuous. In all matters submitted to the African Commission, there will first have been a process of identifying the dispute, seeking to understand and resolve it in an amicable way before the Commission moves to the merits of the claim. The requirement of the existence of a dispute does no more than provide similar opportunities for the resolution of that dispute prior to the submission to this court. A fourth reason for rejecting the applicant's arguments that there is no requirement of the existence of a dispute at the time the application is filed is that this argument fails to give effect to the actual words of Article 3.1 of the protocol. That provision specifically refers to the submission of cases and disputes to the court. The applicant suggests that the word case and the word disputes, as used in Article 3, are interchangeable, and that the court should not, indeed they say, does not make any distinction between cases brought by individuals and those brought by states. This argument as meaning the same thing as the word case in Article 3.1 is inconsistent with a basic rule of treaty interpretation. This is the principle of effectiveness, the basic rule of international law regarding treaty interpretation. According to this principle of effectiveness, it is not open to the interpreter of a treaty to adopt a meaning which would render the text redundant. Words in a treaty must be given effect to. So when Article 3.1 of the Protocol speaks of cases and disputes, the word dispute must be given effect to and cannot simply be interpreted out of the text. The argument of the applicant that case, the word case, and disputes are in this context interchangeable does not stand up to scrutiny because Article 3 uses both. It uses both of these words. It cannot be the case that the drafters meant to speak of the same thing twice. If the two terms are interchangeable, then Article 3.1 is to be interpreted as speaking about the submission of cases and cases, or to be interpreted as speaking of the submission of disputes and disputes. Clearly, the inclusion of the word dispute is intended to add something different in that provision to the word case. For that reason, it cannot be ignored. And we submit that when Article 3.1 speaks of the submission of disputes, that in accordance with the practice of other international tribunals from where this language is borrowed, it specifically covers disputes between states. Mr. Vice President, honorable members of the court, having established that in interstate cases like this one, the court's jurisdiction only extends to the submission of disputes that were in existence at the time of the filing of the application, let me now turn to the application of that condition in these proceedings. So what does it mean in these proceedings? As was set out by the Permanent Court of International Justice in the famous Mavromatis Palestine concessions case, and has been repeated on many occasions, a dispute between states, and I quote, is a disagreement on a point of law or fact, a conflict of legal views or interests, end quote. We have set out in our written pleadings the key principles that are to be used to identify a relevant dispute between the parties. First, for a dispute to exist, and again I quote from the Mavromatis case, quote, it must be shown that the claim of one party is positively opposed by the other, end quote. It must be shown that the claim of one party is positively opposed by the other, end quote. This reference to the claim of one party being opposed by the other relates specifically to the claims that are later brought before the court. It is not sufficient to show that the parties have disagreements or differences in relation to other matters. For there to have been a relevant dispute, the ICJ has stated, and I quote, the evidence must show that the parties hold clearly opposing views with respect to the issue brought before the court. With respect to the issue brought before the court. Second, again, as the ICJ has held, a dispute exists, I quote, a dispute exists when it is demonstrated on the basis of the evidence that the respondent state was aware or could not have been unaware that its views were positively opposed by the applicant. So the respondent state must have been aware or could not have been unaware that its views were positively opposed by the applicant. This means that for there to be a dispute, the applicant must have set out its claim clearly. In other words, the applicant must have made claims which allowed the respondent to understand that the applicant was of the view that the respondent is in violation of legal rights which form the basis of the action, the legal action that is now before the court. Third, while evidence of a dispute can be gleaned from statements that are made by state officials, the court must give particular attention to the content of those particular statements. In particular, a statement will only be said to have given rise to a dispute, or will only be evidence of a dispute, if it refers to the subject matter of a claim, and again I quote from the ICJ, if it refers to the subject matter of a claim, and I quote, with sufficient clarity to enable the state against which that claim is made to identify that there is or may be a dispute with regard to the subject matter. So the statement must refer to the subject matter of the claim with sufficient clarity to enable the state against which the claim is made to identify that there is or may be a dispute with regard to that subject matter. The statement has to articulate an alleged breach by the respondent of the particular obligation or right that is put in issue between the parties in the judicial proceedings. Fourth, the respondent must have had the opportunity to address the particular claim that is made by the applicant. There will only be a dispute where either the claim of a violation of legal right is positively opposed, in other words, it's rejected by the respondent, or the respondent state fails to reply to the applicant's claim of legal violation. Now, judged against all of these principles, it is manifest that there was no dispute between the parties to this case concerning the claims that properly form the subject matter brought before this court. So there was no dispute between these parties concerning the claims that are now brought before this court. The factual record, even as presented by the applicants, reveal that there was no relevant dispute at the time the DRC filed its application. When we say that there was no relevant dispute, what we mean is that at the time when the application was lodged, there was no dispute between the DRC and Rwanda regarding the human rights matters, the human rights claims that fall within the present application. Now, the applicant has tried to overwhelm the court by submitting a multitude of statements and documents which are wholly irrelevant to the issues that properly form the subject of a human rights claim before the court. It has submitted all manner of allegations of supposed wrongdoing by the respondent in order to persuade the court that there was a dispute at the time it filed the application. But what is required is not a suggestion that the parties might have had any type of difference. It has to be shown that the issues that properly form the subject matter of this claim, this case, those issues were in dispute. It has to be shown that there was a disagreement regarding the alleged human rights violations that this court is able to deal with. Now, the applicant has submitted a number of statements in which it accused the respondent of aggression and of unlawfully using force within its territory. It then suggests that those statements in this regard and their opposition by Rwanda constituted a dispute before the application was filed. But this approach and the documents submitted reveal very clearly that there was no dispute between the parties regarding the subject matter within the jurisdiction of the court, violations or alleged violations of human rights. As the court will have noted, the DRC did not, in those documents that it submitted, those documents predating the filing of the application, in those documents it did not allege violations of human rights. They alleged aggression. They alleged unlawful use of force. What those documents show is that the DRC's application is really an attempt to bring matters concerning peace and security before this court. As we will show tomorrow in our presentation on admissibility, this attempt to mischaracterize matters relating to use of force and maintenance of peace and security as within the competence of the court, it permeates the case throughout. And it makes this case inadmissible for several reasons that we will discuss tomorrow. Moreover, as I will show very shortly, claims under the UN Charter, the Charter of the United Nations, under the African Union Constitutive Act, fall outside the jurisdiction of this court, as they are not human rights instruments as set out in Article 3 of the protocol which defines your jurisdiction. But for now, let us look at the statements that the DRC cites in its reply brief as demonstrating the existence of a dispute between the parties. First, there is the statement of the President of the DRC, made in the United Nations General Assembly on the 20th of September 2022. They rely on it in their reply brief. In that statement, he accused Rwanda of making direct incursions into the territory of the DRC and of engaging in occupation. But he did not make any claims of the violations of human rights, the type of violations that this court can actually deal with. True, the President of the DRC referred to the United Nations Charter, he referred to the African Union Constitutive Act, but as I will show shortly, these are not human rights instruments within the meaning of Article 3. There is therefore nothing in that statement that would enable the respondent to know that there was a human rights dispute regarding matters that are now brought before this court. Rather, what was being alleged there was an act of aggression, an allegation that, beside being thoroughly contested, does not fall within the jurisdiction of this honorable court. The DRC further contends that on the 19th of November 2022, that at the 18th summit of the Organisation Internationale de la Francophonie, that its prime minister refused to take a family photo in protest against human rights violations by Rwanda. First, there is no evidence that is given of any particular reasons that were offered at the time by the Prime Minister for refusing to take the photo. Also, it is hard to see how this act of declining to take a photo could possibly fit within the ICJ's jurisprudence that a statement only gives rise to a dispute when it is sufficiently clear in referring to a dispute about the specific subject matter brought to the court. Likewise, in the statement of the DRC's permanent representative to the United Nations, made before the UN Security Council on the 29th of March, 2003, there was no mention made of human rights or of any treaties that this court has jurisdiction to apply. Again, the chief leitmotif of these statements is the allegation that Rwanda has committed aggression. But that is not a human rights claim that is justiciable before this court. That is another matter, and that is not the dispute that is submitted to this court. Mr. Vice President, you may be relieved to know, honorable members of the court, we don't have time to go through all the statements that the DRC refers to in its reply. But when you look at them individually and you take them as a whole, a few things emerge. They do not refer to the human rights treaties that are properly within the jurisdiction of the court. They do not even refer to human rights. The DRC has now, in its reply, adopted commentary that liberally asserts violations of human rights. But the statements themselves do not say so. The statements accuse Rwanda of using force, supporting the use of force, undermining the DRC's territorial integrity, but that is not a human rights dispute. Those are not human rights violations. On occasion, these statements make allegations about specific incidents that they allege has led to loss of life. But again, there is nothing that indicates with clarity that these claims are distinct from the usual allegations of violations of territorial integrity or sovereignty, or even an indication that those allegations of loss of life arise from human rights violations. So to conclude on this first aspect of the jurisdictional objection dealing with material jurisdiction, Rwanda submits that it is a condition of the court's jurisdiction in interstate cases that a dispute about human rights must have existed at the time when the application was submitted to the court. And in our submission, it is very clear that at the time this application was filed, even if there were some differences between the DRC and Rwanda on other matters, it cannot be shown that there was a dispute relating to the human rights treaties or human rights violations that form the basis of the court's jurisdiction. Mr. Vice President, honorable members of the court, let me now turn to the second argument that we have regarding lack of material jurisdiction. That's the argument that aspects of this case fall outside of the material jurisdiction of the court because the applicant relies in part on documents that are not human rights instruments ratified by the respondent. With your indulgence, let me again quote from Article 3, Paragraph 1 of the protocol. I quote again, "The jurisdiction of the court shall extend to all cases and disputes submitted to it concerning the interpretation of the Charter, this protocol, and any other human rights instrument ratified by the states concerned, and any other human rights instrument, any other relevant human rights instrument ratified by the states concerned." This provision is crystal clear. The court has jurisdiction to entertain claims brought not only under the African Charter and Protocol, but also under other instruments, as long as two conditions are met. One, those instruments must be relevant human rights instruments. Two, those instruments must be ratified by the state concerned. Which Rwanda accepts falls within our those instruments. The DRC also includes violations of the United Nations Charter, the Constitutive Act of the African Union, the Pact on Security, Stability, Development in the Great Lakes region, the Peace, Security, and Cooperation Framework Agreement for the Democratic Republic of Congo and the region. Now, I note that in the application that was originally filed by the DRC, those instruments were referred to, but the DRC did not make it clear that it was alleging a violation of those instruments. However, in its reply brief, the DRC clarifies that it was indeed alleging a violation of these instruments. Rwanda submits that the court does not have jurisdiction to deal with alleged violations of the four instruments I have just mentioned. This is because, one, they're not human rights instruments. In the case of the Great Lakes Pact, and in the case of the Peace, Security, and Cooperation Framework, they are not instruments ratified by Rwanda or indeed by any other state because they are not treaties. To make a definitive finding that these instruments, these four instruments, fall under the jurisdiction of the court. It also alleged that some of this conduct also violates the African Charter or other human rights treaties. As a general matter, the jurisdiction of the court is defined by the consent that states have given. And the court should, and indeed must always, be careful to ensure that it is sticking to the competence it has been given. States have only given the court a mandate to deal with violations of human rights instruments that are binding because they have been ratified. No more than that. In this specific matter, the DRC tries to muddy the waters by mixing matters relating to peace and security with human rights claims. This is a human rights court that is tasked with dealing with violations of human rights. The applicant does not hide its intention to draw this court into deciding on matters relating to the use of force. It says very clearly in its reply, and I quote, "There is an inextricable link between human rights and the use of force, peace, and security. The use of force by one state, Rwanda, against another state, the DRC, as in the present case between these two states, has a negative impact on human rights in that it generally leads to the violations of these rights." end quote. In other words, the applicant is suggesting that whenever there are this court will automatically have jurisdiction to deal with such a case under the guise that this is a matter concerning human rights. Nothing will bring this court into greater disrepute than this sort of argument. And such an attempt to broaden the jurisdiction of the court beyond the mandate that it has been given must be rejected. The other point that is of relevance here is that by insisting that the court has jurisdiction to deal with claims under the UN Charter and the AU Constitutive Act and other peace and security instruments, the DRC seeks to claim that the matters it now brings to the court are the matters that were already in dispute between the parties at the time when it filed its claims. As I showed you, the DRC made reference to a number of statements in which it claimed that Rwanda was using force on its territory, allegedly in violation of the UN Charter and the AU Constitutive Act. In arguing that these are issues within the jurisdiction of the court, the applicant is trying to show that there was some continuity between the issues that were raised in those statements and matters that are now within the jurisdiction of the court. If the court were to confirm that alleged violations of the UN Charter, the AU Constitutive Act, and other instruments relating to peace and security do not fall within the jurisdiction of this court, this would also confirm that there was, in fact, no dispute between the parties relating to human rights prior to the filing of the application. Let me now turn to the two conditions that I referred to in relation to these instruments. The test for ascertaining whether an instrument is a human rights instrument is fairly simple, and it has not been particularly contentious. This court has been very clear as to whether it considers an instrument to be a human rights instrument. You stated in one of your previous cases, Action pour la protection des droits de l'homme against Côte d'Ivoire, you stated, and I quote, "In determining whether a convention is a human rights instrument, it is necessary to refer, in particular, to the purposes of such convention. Such purposes are reflected either by an express enunciation of the subjective rights of individuals or groups of individuals, or by mandatory obligations on states parties for the consequent enjoyment of human rights, of the said rights, sorry. I repeat, such purposes are reflected either by an express enunciation of the subjective rights of individuals or groups of individuals, or by mandatory obligations on states parties for the consequent enjoyment of the said rights." The key requirements here are very clear. There has to be an express enunciation of the human rights in question in that instrument, or obligations have to be imposed on states with regard to the said rights the particular rights that are in issue. The DRC makes an issue of the translation of this passage that I have just quoted. And they argue that it has a slightly different meaning in the French translation. The DRC argues that the French version of this judgment shows that the instrument does not need to set out binding obligations. However, in making this argument, it has left out relevant wording that undermines its argument. The relevant paragraph from that judgment does not simply state that the obligations in question are, and permit my very, with your indulgence, I'll use my very poor French. So the judgment does not really state that the obligations in questions are obligations impliquant la jouissance, as stated by the applicant. Rather, this judgment referred to la prescription à l'égard d'État. So the stipulation of obligations regarding states that involve the consequent enjoyment of human rights. In short, the instrument must provide for binding obligations with regard to human rights. Now, we do not argue that a treaty is only a human rights instrument if it exclusively deals with human rights. However, we do say that when the court speaks of an express enunciation of subjective rights of the individual, it does require that specific rights are set out in the instrument. Although the UN Charter and the AU Constitutive Act refer to the promotion and the protection of human rights, when listing the aims of those organizations, neither instrument actually sets out specific rights. They do not include an express enunciation of such rights, nor do they provide obligations regarding the enjoyment of any particular rights. The applicant suggests in its reply that the court has held that the Constitutive Act of the AU and the UN Charter are human rights instruments because the court has referred to such instruments in its judgment. With regard to the AU Constitutive Act, the applicant refers to the judgment of this court in the Mohammed Abubakari versus United Republic of Tanzania case, where it is true that the court did in fact make reference to the Constitutive Act of the AU. However, that case in no way supports the applicant's position. The issue in that case was whether the application was admissible. And what the court was considering was whether the provisions in what is now Article 50, Paragraph 2b of the rules of the court on admissibility had been complied with. One of those conditions in Article 50, 2b, in fact, a condition that Rwanda has invoked in this very case, and which my colleague will elaborate on tomorrow, is that the application must be compatible with the Constitutive Act of the AU. In other words, the rules require that the application must not violate the Constitutive Act. Let us be clear what this requirement means. It is the application that must not violate the Constitutive Act. It is not that the court is to examine whether the conduct of the respondent is a human rights violation of the Constitutive Act. In fact, in the Mohammed Abu Bakari case, it had been argued that the application was inadmissible because the applicant had not alleged breaches of human rights in violation of the Constitutive Act. It was in response to that argument that the court explained that the provisions of the rules, which say that the application must not be incompatible with the Constitutive Act, does not render, or in that particular case, did not render an application inadmissible because it did not allege that the conduct of the respondent violates the Act. It was in that context that this court stated, and this is what's important, and I quote, it's in that context that this court stated, I quote, "The violations alleged in the application are susceptible to be examined by reference to the Constitutive Act and or the Charter, and are not manifestly outside the scope of application of those instruments." In other words, examinations of the violations of the human rights instruments must not be debarred by some incompatibility with the Constitutive Act. That was the point. So there's nothing in that case that suggests that the Constitutive Act is a human rights instrument. Let me now turn to the UN Charter and whether it is correct to say, as the DRC does, that this is a human rights instrument within the meaning of Article 3 of the Protocol. It's true that members of the UN, in Articles 55 and 56 of the Charter, pledge to take action in cooperation with the United Nations Organization for the achievement of respecting human rights and fundamental freedoms. However, the Charter does not anywhere specify any particular human rights, meaning that the express enunciation of rights that this court has said is the standard for a human rights instrument is absent. Furthermore, it is hard to say that Article 55 and 56 specify clear obligations with respect to human rights, such as this court would expect from a human rights instrument. In exactly the same provision, members of the UN also pledge to take action to achieve full employment, higher standards of living, solutions of international economic and social problems. But we do not then say that there is a violation of the UN Charter when these lofty goals are not achieved. The applicant, in its reply brief, suggests that this court has found that the UN Charter is a human rights instrument. They refer to the case of Frank David Omari and Tanzania. However, this is incorrect, as the applicant, again, misunderstands the court's reference to the UN Charter in that judgment. In that case, what the court actually said was, and I quote, "In fact, Article 60 of the African Charter authorizes the court to draw inspiration from international law relating to human and people's rights, in particular from various African human rights instruments, the United Nations Charter, the Constitutive Act of the the Charter of the Organization of African Unity, and the Universal Declaration of Human Rights." To understand what the court was saying in that case, it is important to note that Article 60 of the African Charter is actually directed at the Commission. It is the Commission which has a different mandate that is specifically directed to draw inspiration from those materials. Now, this is important because though the court says that it may draw inspiration from those materials, it is clear that the court can only draw inspiration from those materials once it is established that it has jurisdiction. And the court's jurisdiction is only established after it is determined that the application is based on a human right instrument ratified by the state concerned. In fact, it's very clear that in that case, the Omari case, the court was not using those materials to define what is a human rights instrument. Very clear, because the court in that case lists the Universal Declaration of Human Rights, and then the court clearly says that the Universal Declaration of Human Rights is not one of the human rights instruments that fall within Article 3 of the protocol. So all the court was saying is that once jurisdiction is established, it can draw inspiration from international human rights law, for example, to interpret the instruments that are in fact within its jurisdiction. In summary, there is nothing in the court's case law that deviates from the starting point, that in determining whether a particular treaty is a human rights instrument within the jurisdiction of the court, that treaty has to contain an express enunciation of the human rights in question. The Constitutive Act of the AU, the United Nations Charter, do not do so, and thus they are not human rights instruments within the meaning of Article 3. Mr. Vice President, honorable members of the court, let me now briefly turn to my final point. And this is the second reason why some of the instruments relied on by the applicant fall outside the material jurisdiction of the court. This is the requirement that not only must the instruments be a human rights instrument, it must be one that is ratified by the states concerned. In other words, the court only has jurisdiction to consider violations of treaties that the respondent state has become party to. Only treaties are ratified by states. The drafters of the protocol chose their words carefully. The purpose of this requirement is only to include within the material jurisdiction of the court allegations of violations of instruments that are explicitly ratified by the respondent. The DRC seeks to found the jurisdiction of this court, in part, on the Pact on Security, Stability, and Development in the Great Lakes region, and on the Peace, Security, and Cooperation Framework Agreement for the Democratic Republic of Congo and the region. However, these are not treaties ratified by states, and certainly not by Rwanda. Thus, even if they were to be regarded as human rights instruments, a characterization that Rwanda disputes for the reasons I have set out, they fall outside the material scope of the court's jurisdiction. Despite this very clear text, and indeed it could not be clearer, we were very surprised to read in the applicant's reply brief the suggestion that this court's case law says the opposite of what the protocol provides for. The DRC says that it is not essential for every human rights instrument to have been ratified in order to establish the court's substantive jurisdiction. I'm sure that this will come as a surprise to the court too. To justify its claims that the court has jurisdiction over alleged violations of instruments not ratified by the states concerned, the applicant refers to cases where it says the court has applied the Universal Declaration of Human Rights. The Universal Declaration of Human Rights, it's not a treaty. It has been referred to by the court, but the court has been clear, crystal clear, that the Universal Declaration is not a human rights instrument that falls within Article 3. Reference was made by the applicant to the Frank David Omari case that I've just referred to, Frank David Omari and Tanzania. There, this court ruled in paragraph 74 of your judgment that reference to the Universal Declaration is permissible, and I quote, as long as the alleged violation is also provided for by a treaty ratified by the state concerned. This court, end quote, end quote. This court then went on to state, in the very next sentence, as if for the avoidance of any doubt, this court then stated, quote, the court has the power to exercise its jurisdiction over alleged violations in relation to the relevant human rights protection instruments ratified by the respondent, end quote. So not only is the text of Article 3 of the protocol very clear, the case law of this court is also clear. For the court to have jurisdiction, the instrument must have been ratified by the respondent. For this reason, we submit that allegations of violations of instruments that are not treaties fall outside the material jurisdiction of the court. Mr. Vice President, honorable members of the court, with your indulgence, let me bring my presentation to an end by repeating Rwanda's submissions that the application must be dismissed because, one, the case falls outside the territorial jurisdiction of the court, and two, because the case does not fall within the material jurisdiction of this court. Honorable members of the court, this concludes Rwanda's presentation on jurisdiction this morning. I'm very grateful to you for your kind attention.
Merci pour les exceptions soulevées. À présent, nous allons observer une pause d'1 heure de temps. Au retour, il y aura l'État requérant qui va plaider en réplique sur les exceptions d'incompétence.
To present its objections regarding jurisdiction. Thank you very much.